lay out the 5 points we're announcing today that are our best effort to clean up this operation so that when I'm Attorney General, no one will ever doubt that lawyers for this panel and this assignment, as well as for other areas, are picked because of the merits and have nothing to do with campaign contributions. Not because I'm just saying it, because there's a process that reflects it. And what we've tried, I've talked to a number of experts around the country, AGs who do this the right way. That's helped inform a lot of what's on this sheet here. But let me go through a couple of them one by one. And this, I promise this won't take very long. The first is transparency. One of the key ingredients to pay to play is a lack of transparency. And right now, even though you are the top flight reporters for the state of Ohio, I bet you only a couple of you even know who does the work that we're talking about for securities litigation. Because it's behind closed doors. It's not up front. And so you can never figure out what's going on pay to play if the people who are actually playing, if it's behind closed doors. So our first commitment is transparency. If you are doing work for the state of Ohio, if you have the honor and privilege of representing our pension funds or our universities, you will be on a website of the state of Ohio Attorney General's office where everyone can see that you're on that list. And the terms of your agreement will be in that list, and your proposal will be on that list. So that unlike today where it takes reporters, and some of you have gone through this, years to dig up who actually is doing the work, which then allows you to trace who's getting it for good reasons and who's not, we will put on our website, from as soon as I get there as possible, who actually is on the securities panels, who is doing the other work. If there's certain privileged information, we'll obviously leave that out, but to the best of our ability, we will include every single lawyer, law firm who is doing work for the Attorney General's office, every citizen, every reporter, and anyone else should be able to see who that is. That is one of the key ways to root out pay to play. We actually know who's doing the work. Right now, it is literally a multi-month homework assignment to even figure that out. Number two, another key ingredient that allows pay to play to happen is the lack of any kind of standards, objective criteria, written, published in the system. And if you don't have that, then you have it's too easy to say that you're picking on merit, but to actually not be doing so. And so the second thing we will do, and to the best of my knowledge, this is not the case today in the Attorney General's office. In addition to making it clear who actually is doing the work, we will have clear criteria on how they are selected. It will be written, recommendations will be written, it will be transparent, it will be scored, it will be analyzed, so that if anyone, yourselves or others, wants to know why someone was picked, you will see it in the numbers. And when you ask the Attorney General today, did you pick based on merit, did you pick based on contributions, the answer is, here's the score sheet, it was merit. Not it was merit because I say so, but there's actually proof of it. There's actually documentation of it. And we will do that. Now this to the rest of the world does not seem like an earth-shattering idea, does it? You know, when I was on the county commission in Hamilton County, and we were letting out construction contracts, that's what we did. You had the sheet, as a county commissioner, you had very little discretion because you had come back to you, here are the lowest and best bidders. And the sheet would show who bid for what, and we would pick the best bidder. There's no reason that should not be happening in the Attorney General's office, especially if the job is to be a role model of doing this the right way. The third piece, so opening it up, clear merit-based system, that should take us most of the way. We've just gotten rid of two of the most important ingredients that have allowed for pay to play. Third is extra protection on this. The third is creating, and this is something that North Carolina's Attorney General has been doing, create an independent review board that screens the initial RFQs, the request for qualifications, and put on this board the people who actually have a stake because they're the end client. Have some expert legal folks, maybe a retired federal prosecutor or a retired law professor and legal experts, but also how about a member of the pension board? How about a teacher on the pension board? Or how about from the police and fire? Let them actually, they have the greatest stake that this be done the right way. Put them on a board that screens the original bids. And let them then make the recommendation to the Attorney General. Now the Attorney General needs to have the final say as a top lawyer, but let them make a written recommendation that once again reflects, and they're doing it based on the criteria we've laid out, let them do a written recommendation after a true neutral assessment, and no one on that board has any is connected at all to the Attorney General's office, and obviously not to the Attorney General's campaign. No lobbyists, no one with any interest. Have them do the initial screen. The first thing that does is it means that people who have, in many ways, the greatest stake in having the best quality have a seat at the table. It also means that you, I think, weed out through this process the danger that some people are getting into this who aren't high-quality lawyers, but they've given $100,000. This group will ensure that doesn't happen, and they're using the criteria that we've laid out. That's point 3. Point 4. Maybe the most unseemly part of the story that you saw a couple Sundays ago was literally the exact timing of checks on the day proposals were submitted. Think about that. On the day that proposals were submitted, the same day, in some cases, the same person who signed the proposal sent a check to the Attorney General's campaign. In some cases, the checks went over the limit or were illegal. That is, when you're looking at red flags, that's about as bright red as it gets. And it just obviously, to me, looks, seems, and is inappropriate. And the worst part, perhaps, is that except for one firm whose head lawyer had been in trouble and ultimately was disbarred, every firm that sent checks on the same day got work. Firms that sent checks a week after they sent the proposal in got work. Firms that sent, other firms got work and then sent a check the week after. So my view is those are the checks that are most troublesome. But in the last couple of years, the success rate of people sending in checks on the same day has been incredible. Almost 100%, except for one person who had frankly was about to lose their law license. So that's got to end. And a lot of other processes, that's not allowed. And so as Attorney General, I will establish a hard blackout on any contributions in the months before, during, and after any RFPs where people are bidding. And I will make it clear, you should not send, and we shall not accept any checks that you're sending to me or the party or anyone else in the middle or before or right after bid process. In the current system, it looks like those checks were all rewarded because everyone did it but one got the work. And again, I think there were something like 4 firms that sent them on the same day. A number of firms sent it the week after. It is a clear pattern, and we'll clean that up because that is obviously, you combine that with these other factors, very unseemly we're seeing that. And the final part is that we would require, in addition to, and I think this is something that I can't remember their name, but Catherine Terser has been pushing for a while. We'll also require disclosure in the proposals of contributions that have been given the prior 2 years. So that does a couple of things. One, it makes it clear for everyone to see what people have given, and when you make decisions, that information will be on the table. Number 2, it also means you don't have illegal contributions and ultimately select those firms, which is what happened in this case. Right now, it simply says, have you given an illegal contribution? Everyone checks no, and that's the end of it. With this, we'll actually have the facts to make that decision, so there'll never be a moment where you actually are giving work to someone who is barred from doing it. These are the 5 key steps. Now, I put in here steps that I know as Attorney General I can do all on my own. There are probably many other good ideas, and I invite and would welcome the legislature bringing forward their ideas. I think this is important enough, especially with the tie to pension funds, that they look at this as well. There may be things they could do. I certainly am open to other ideas, but these are 5 things that I know. If you look at what causes pay to play, it's mostly the lack of these things. And if we put those into place, it sends a signal that pay to play is not welcome in Ohio. It also eliminates there's so many checks and balances in these 5 steps. It eliminates any opportunity for pay to play to happen without everyone knowing about it. For example, everyone knows who the firms are. Everyone knows what the standards are. There's a paper trail of recommendations. If after all that, we know how much people have given. If after all that, the Attorney General picks the biggest donors, ignoring all these reports, it'll be as clear as day. There's just no temptation anymore to do the kind of things we're seeing where it's completely tied to donations. So